Hello, everybody.
Mr. Williams. Are you Williams? Good morning, Mr. Bowditch. Your appearance for Mr. Williams.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Williams. Your Honor, today's the date and time set for a show cause and arraignment in this matter. We waive formal reading and stand mute. We've also had a chance to pre-try this case. We do have an executed plea agreement subject to court approval, along with a little explanation. But Mr. Williams would be pleading guilty to a fishing violation, with the understanding the matter would be taken under deferred sentence for a period of 90 days. If he complies with all the court's wishes, the court hopefully will consider dismissal of these charges.
All right, Mr. Williams, you understand your rights and options?
Yes, sir.
You understand the possible penalty for the charge?
Yes, sir.
Understanding all of that, are you pleading guilty to the charge freely and voluntarily?
Yes, sir.
Did you, on May 24, 2024, take some fish out of Belleville Lake at the Belleville East launch? What I've got a notation is 2 smallmouth, 1 largemouth out of season, correct?
Yes, sir.
Satisfied?
Satisfied, Your Honor.
Anything I should consider before I sentence?
Your Honor, the season started the next day.
But it
So-
didn't start the day before.
Nope, but I consider that the fish's fault. But
Well,
here
but-
he is.
That's
Because you just
because you're
mind-
from the South.
He's just minding his own business. And this fish just jumped on his hook and got him in trouble.
See, I've read these statutes, Mr. Williams, and suicidal fish are no exception.
Yes, sir.
Anything
He
else I
promises
should-
he will sin no more.
All right. So court costs are assessed the amount of $145. I'm assessing 3 restitution fees to the DNR of $20 each. So that's $60 in restitution, $145 in court costs for a total of $205. Can you pay that today or do you need some time?
I need some time.
Go downstairs and work out your options.
I get part of it.
Go on downstairs. We got options.
Okay.
All right. Stay out of trouble.
Thank you, sir.
Are we ready on the Peterson matter, folks?
Morning, Judge. Can you hear me okay?
I can.
Defense is ready.
People are ready, Your Honor.
All right. If you two put your names on the record for me, we'll get started.
Good morning, Your Honor. Sarah Bonoma on behalf of the people, P84189.
And good morning, Judge, to you and your staff, Robert Burton Harris, P81843, on behalf of Mr. Chris Peterson, who's present, zooming in from the Wayne County Jail, since this hearing being conducted on.
Thank you. And Mr. Peterson, can you hear everyone all right?
Not really. Just give me
Not really? You want us louder?
a little louder.
All right, we'll try that. All right, counsel, I understand we've got 2 items up today, both from you. One is order of indigency and the other is a bond reduction, correct?
Yes, that's correct. There's two issues.
All right, well, let's take the
Want me to address
indigency
that now?
first, just because that happens to be on the top of my file. People have any position? I'm assuming you've seen the documentation, counsel?
Yes, Your Honor. I don't have any further information besides what he put in the motion, so I would have no position.
All right. So what you didn't tell me is any information so I could make a determination the guy's broke.
Well, I did include where he works, and I looked at my notes, and how much he makes per hour just escaped me, so that's why I didn't include it in my motion. I did indicate that, because Mr. Peterson is present, if you had any questions about how much money he actually had access to or made, he certainly can answer those questions for you directly. I don't believe that he makes more than $23 an hour, and I know that he was working part-time. So to the extent that he's able, he just can't afford investigators and experts in this case.
Okay. All right, Mr. Peterson, where do you work, sir?
Guardian Angel Care, which is my mother's
Yep.
company. That's a home health aid, helping elderly people.
I am, Your Honor, and I apologize. I'm having a lot of.
Mr. Bickert, I'm in the middle of something else right now. I'm sorry, Mr. Peterson. Why do you work part-time?
Said, I also work
Why
with
are you
my
working
father.
part-time?
Because I also work with my father. He owns a lawn service company.
So you have two part-time jobs.
Yes, sir.
Okay, and how much are you paid hourly on both jobs?
With guardian angel care, I get paid 15 an hour. And the lawn service is, I don't get paid hourly. I just get paid at the end of the day. Actually, I get paid 15 hours from that too.
All right, and how many hours a week do you work between the two jobs?
I'm
Are
not
you,
too
are you
sure.
averaging 40 hours a week, 50 hours a week? How much are you working?
Probably like 20.
Then go get a third job.
Yeah, about time.
How old are you?
24.
Are you healthy?
Say it again.
Are you healthy?
Healthy? Yes.
Then you should be working 70-hour weeks.
Can I add something for the court's indulgence, Judge?
Not unless you got a job for him.
Well, well, what I was going to say is that what Mr. Peterson is not including is sides with his younger sisters and a cousin, who he also helps out with on a daily basis. So it's not that he's just kind of sitting around not doing anything. It's just that he has other obligations as well.
He ain't working as hard as he should be, I can tell you that. I'll sign the order. Let's talk about the bond.
Appreciate that, Judge. So I think it's pretty clear from the motion. I kind of laid everything out. He's 24 years old, no criminal history whatsoever, never been in jail, never been in custody. This case is a prima facie case of self-defense to the extent that that will be the defense. Frankly, Judge, I don't even know, and this is something I'm researching. I don't know to what extent the prosecutor is going to be even able to argue that the decedent in this case was not violent, and so the likelihood of conviction on this charge is extremely low, to say the least. As I put in my motion, he, like I said, has never been in jail. The Wayne County Jail is not staffed and not appropriately staffed, I should say, to be able to protect him long term. And so the magistrate who arraigned him, after I explained the circumstances of this case, felt that because initially his gut reaction was to just remand him because of the charge. After I explained the details of the case, he changed that so much that he didn't even order a tether for Mr. Peterson, but he still kept the bond at a $250,000 cash amount, which was just completely unaffordable. Mr. Peterson is obviously not working, or he's in jail. He doesn't make a lot of money to the extent that his family could afford to retain me. They don't have the money to pay a $250,000 bond. And so, Judge, I'm asking for a personal bond because there's really just no reason not to give him one. I think the best indicator of future behavior is past behavior. And this case, officers arrived. Mr. Peterson was sitting on the end of his driveway with a gun next to him that was made safe, with his CPL and license on top of the gun. So he's clearly indicated that he's in no way, shape, or form a flight risk, and he's certainly no danger to the community based on what I said. Sister Counsel has sent me most of the discovery, I think, on their end so far. And so this was captured on video. You can see that what's on video supports what he told the officers to the extent that those statements are going to be admissible. So there's just really no reason to have him in jail other than the specific charge. But obviously that is not the only factor when you consider bond.
Thank you, counsel. Response from the people.
Your Honor, just to start, so just briefly touching on the facts, we have ring camera of the victim parking across the street from his girlfriend's house or his ex-girlfriend's house, a couple houses down. We have the defendant, which is the defendant's mother. That's her boyfriend or ex-boyfriend, I'm not sure. We have the defendant who's trying to ask his mother, is that the victim? Is that the victim out there? But he can't get a hold of her. She's in the shower. That's when the defendant and his cousin calmly, casually walk across the street, armed with a gun. The victim exits his vehicle, goes to the passenger side to approach them because they have already approached him. There's some kind of conversation that took place, and then the defendant shot at least 7 times, if not more. There's no gun recovered off the deceased. The defendant doesn't say he had a gun when the police come. The cousin doesn't say he had a gun when the police come. They casually and calmly walk back across the street, all on ring camera, as the mother is hysterical. She's screaming, "Why would you do this?" He pulls up a lawn chair and he sits and waits for the police to come. I want to talk about the motion that defendant submit to the court. It says the shooting occurred at his home. No, it didn't. He was in the safety of his own home. He chose to leave the safety of his home and to confront the victim. He decided that in that moment, he's going to be judge, jury, and executioner. And then in the motion, it says the deceased has been abusing, stalking, threatening, harassing Mr. Peterson's mother, himself, and his family for years prior to the shooting. That's not self-defense then. He knows what he's doing. He went over to confront the deceased and he had a gun. He knew exactly what he was doing. The shortage of the Wayne County Jail is not permission for someone to get a personal bond. The fact that he's not familiar with jail, that's what the defendant's saying. I'm not familiar with jail and violent offenders, so I shouldn't have to sit in prison. He's the violent offender. The argument maybe can be made for someone on a CCW or a little possession charge. This is a homicide second degree. I think $250,000 bond is way too low for a homicide. I am asking for a remand of the bond, and I'm asking for an exam. And after the exam, after the court has the opportunity to review the evidence, then we can address bond, Your Honor.
All right,
May I have a last word?
Mr. Burton Harris, anything else?
Yeah, so for a couple things. The defendant's statements support everything that's on the video, and I don't think the sister counsel said otherwise. I'm not sure how she said that.
Hold on. I lost your audio.
Can you hear me okay now?
Back way up. Back way up. You blanked out.
Okay, so I was just saying that I just want to address a couple things sister counsel said, and didn't say. The video supports exactly what he told the officers. I don't know how sister counsel knows what was said, because she's correct. The ring camera is from across the street, so you can't hear the conversation, but you see the my client backing up. You see the decedent coming at him and his 16-year-old cousin who was standing right there. So she's correct that it was across the street, and if I put it in my motion that it was at his house, that was just inartful on my part. But the shooting did occur across the street. So that's one thing. In terms of the reasons for confinement, sister counsel has flat out asked you to do something that's unconstitutional, in the sense that she wants a high cash bond expressly so he can't get out. It's not connected to dangerousness. It's not connected to any type of flight risk whatsoever. In terms of what the mother said, I'm not exactly sure why that's relevant at all. I cited in my motion multiple police reports, multiple criminal court cases that were prosecuted by this prosecutor's office for the decedent. So the question about his dangerousness and whether or not my client has the right to go and speak to somebody because he has a CPL and carry a gun, I think Your Honor knows that is his protected right, and that he can do that. The fact that the prosecutor has acknowledged and doesn't dispute this prior threat, stalking, et cetera, it honestly just kind of baffles me, because the idea that my client has to stay in his house when there is a threat that has been ongoing and outside is not consistent with the law. And so if Your Honor is inclined to do some cash bond, his family cannot afford to pay more than $4,000. So I would ask that you would make a $40,000 cash or surety bond with a 10% provision, so that they can post it. He can face these charges. He's already demonstrated he's not a flight risk. And in terms of him being in danger, I think we've already addressed that. And sister counsel hasn't said anything to dispute the circumstances of this shooting.
And Your Honor, if I can briefly.
Sure.
I guess the first thing is I'm not agreeing that there's been abusing and stalking and threatening. That's the defendant saying that. So how are you going to come back and say now it's self-defense if this has been going on? He knows what he's doing. He's also asking to drag the deceased through the mud about his criminal history, his past. And he's citing a 2005.
Counsel, let me stop you. I have to agree with defense counsel. I don't think you understand the purpose for which I set bond. You want to try the case today. Tell me why this individual is a danger to himself or others. Tell me why there's a danger that he won't show up. That's what I'm supposed to be determining today.
Okay, well,
I'm not
I
trying
can't
the
say,
frickin' case.
I understand, but I can't say that he's not going to show up because he doesn't have a criminal history. So I understand that. But he's charged with homicide second degree. And we can't just.
I read
defendant
the
doesn't-
file, counsel. I know what he's charged with. Tell me why he's a danger to himself or others.
Because he just killed someone and it's not self-defense. The other individual did not
And you
have a
know
gun.
that how?
Because the other individual did not have a gun. He even said to the police, the defendant said to the
Okay,
police.
you've told
he
me
got
all I
there.
need to know. You've told me all I need to know because obviously the only reason deadly force is justified is if the other person has a gun.
And what the defendant said, what the defendant said to the police and what his cousin
Your
said.
motion's granted, counsel. The bond is changed to $1 million personal. What's the next court date?
$1 million personal bond.
Thank you, Judge. I've heard your staff say that you were available for exams on August 28th. And our defense is free on that day as well.
28th of August. Does that work for the people?
Yes, Your Honor.
And what time would this be, Judge?
How many witnesses are you thinking? How long do you think it's going to take us? Because I need to set up pick the scheduling.
I would probably anticipate at least 4 witnesses, Your Honor. And Your Honor, I'm sorry. I know you already made your ruling. Can I just mention one more thing just so the court?
No, because as you said, I've made my ruling. Now we're scheduling the exam.
Okay.
Defense, how many witnesses you think?
I'm thinking 2. Can you hear me okay, Judge? Can you hear me okay, Judge?
I think it's 1. All right, call it 1 p.m. on August 28th. Good day.
Thank you, Your Honor.
Thank you, Judge.
Thank you so much for coming out tonight. Be safe, be well, sleep sweet, and much love.